Good morning. My name's Jeremy Levy, and I'm an attorney in Toledo, Ohio, practicing in the areas of criminal defense, civil litigation, and domestic relations. Today I'm going to be talking about divorce. All divorces have 5 common issues that need to be dealt with. The first 3 include dividing up assets, allocating debts, and dealing with spousal support. The last 2 deal with children. Custody and visitation, which I put into one category, and child support is the 5th. Those are the 5 issues that you need to consider when dealing with a divorce. In Ohio, this is a community property state, and that means that anything acquired during the marriage is considered marital property. This is also an equitable division state, which means that the courts want to divide it fairly and equitably. All assets that you had going into the marriage are premarital, and with the exception of certain gifts and inheritances, anything else acquired during the marriage, assets and debts, are marital. Spousal support deals with keeping the person who receives the lesser amount of income at a standard of living that they've become accustomed to. There is no equation for determining an amount of spousal support, but courts will often look at the disparity between incomes as well as the length of the marriage. A general rule of thumb is that spousal support will last for approximately 1/3 of the length of the marriage. Spousal support is not factored into very short-term marriages. And the idea of the amount of spousal support depends on the difference between the 2 parties' incomes. The court just wants to make sure that one party isn't living in a mansion while the other party is living in a trailer. They want to keep the parties as equal as possible and give the less earning income party an opportunity to get some training and education to raise their income so that they can remain at the standard of living they've become accustomed to. Now, when dealing with custody and visitation, there are 3 options: custody to mom, custody to dad, or a shared parenting plan. A shared parenting plan simply means when the children are with mom, mom's the custodial parent, and when the children are with dad, dad's the custodial parent. Courts do ask that you determine who is the residential parent for school purposes, meaning the parent whose address determines the school district the kids go to school in, and also who's the residential parent for medical purposes. This includes all non-emergency medical decisions. If the kids are with you and there's an emergency, no one cares who the residential parent is. But if we're talking about non-emergency decisions, like who the children's pediatrician is or whether or not they get braces or not, that will fall as to the responsibility of the residential parent for medical purposes. Finally is child support. Child support is paid to the custodial parent by the non-custodial parent. Child support is often determined by looking at the child support guidelines, which is usually determined by plugging in numbers of income and expenses, and a software program determines a reasonable amount of child support. There are reasons to deviate upward or downward from that number, and those factors are listed in the Ohio Revised Code. Some examples might be if the non-custodial parent has a 50-50 time split or incurs additional expenses not included in the child support guidelines. These could be reasons why we would deviate on the child support numbers. If you are anticipating going through a divorce, please feel free to call my office at 419-243-8989 to schedule a free initial consultation, or visit my website at www.toledo-attorney.com for more information on me, what I do, and the law. I hope this was valuable to you. If you have any questions, feel free to give me a call or shoot me an email through the website. And remember, if you need an attorney, call Jeremy Levy, attorney at law. Thank you.